102, People versus Dryden. Counsel, any rebuttal time?
3 minutes, please, Your Honor.
Sure. Go ahead.
May it please the Court, my name is John Schofel for Mr. Drayden. The issue here is whether the misdemeanor complaint that merely stated without anything more that Mr. Drayden possessed a gravity knife was conclusory and jurisdictionally defective.
What more should it have stated, or could it have stated, or did it need to state?
What it needed to state was enough facts to infer that the simple flip-open test, which is necessary to differentiate this type of per se weapon from ordinary folding knives that it closely resembles.
Well, it is a term of art that is defined. Gravity knife is defined in the penal law, right? Section 265, subdivision 5.
Yes, there's a
So do they have to repeat that specific definition?
Well, if he had done that, and he had specifically done that, we would have more of a basis to infer that he had made the test. Because the test depends
why
on,
do you have to repeat the language of the statute if it's a defined term?
It wouldn't have been enough merely to do that. I mean, our position is the test should be that there has to be enough facts that he's actually flipped it open, it actually opens in the way it has to, and locks in the way it has to.
Wasn't this a box cutter? Wasn't this some sort of box cutter that flipped open?
This is part of the trouble in this case is there is no assurance about what this thing was.
But he didn't complain about that, did he? I mean, he said, I'm guilty of possessing a gravity knife.
Right. During the plea allocution, he said, I call it a sheetrocking knife. I was using it to cut boxes. Defense lawyer said box cutter, and the trial and the plea judge said.
You're not saying it's an inadequate allocution.
I'm not challenging the allocution. I'm saying that the reason why we need evidentiary factual allegations, which is what the legislature has specifically says applies to complaints, and what this court in Dumas and Alejandro and most recently in Kalin and Jones has reaffirmed that we need evidentiary allegations. We can't
Was this enough, do you think, for your client to prepare a defense? Did you know what he was charged with and get his defense ready?
Notice is not enough, Your Honor.
Okay, but I understand that point, but the answer to my question is yes, it was enough?
We don't have a notice claim specifically raised in this case.
And do you have a claim that this would not have been enough to protect him in a double jeopardy problem if he were prosecuted twice?
That's not the claim. The claim is that the statute.
But doesn't Kalin suggest that if you meet those two tests, then the guilty plea forfeits anything else?
I don't think Kalin suggests that, Your Honor. Because in Kalin, there was a conclusory allegation about what the substance was, but then this Court looked beyond that and found several other factual allegations from which you could infer it, including two types of substances not open to public view, training, experience, paraphernalia with it. We have none of that.
How much more do you need here?
You need – our position is you need the flip over.
For instance, what would you say?
Well, what happens in almost all of these cases, in reality, in practice, is the officer says, I opened it, it opened with centrifugal force, it locked into place automatically. That's enough. That's what happens. In this case, there is no such allegation like that. We shouldn't infer, because this case differs from all the other cases that he did.
That sounds like what would have to be alleged in the misdemeanor information, but you waived the information.
Well, I mean,
so
as a practical
what's the difference between the complaint and the information, then, in connection with a gravity knife?
Well, obviously,
sounds like you're looking for the same factual basis to be in both.
As a practical matter, in many or even most cases, the factual allegations necessary to establish reasonable cause, which is the crux of the complaint requirement, and the prima facie case are the same. I mean, what happens in most cases is the further allegations start to eliminate hearsay.
Well, the issue of operability, that goes to the probable cause, doesn't it?
Well, yeah, the operability is the whole nature of – that's why this is a unlawful item. It opens and locks in a certain way. So it's not like some
what is an inoperable – I mean, I think I know what an inoperable gun is, but what's an inoperable gravity knife?
It's something that most of us have in our houses and can buy anywhere. It's a folding knife that either requires manual locking or the blade has what they call technically a biased
You mean an ordinary Swiss Army knife?
That would be it
You
would
call
not
that,
qualify.
it wouldn't be kind of funny to call that an inoperable gravity knife?
I mean, I think it's pretty obvious that even an officer wouldn't think that was a gravity knife. But there are many cases, and as a practical matter, often these things are mistaken for perfectly lawful items that have lawful uses, are sold in major department stores. I mean,
I guess
that's
what I'm asking is there really any difference between discussing whether something is a gravity knife and whether it's an operable gravity knife?
Basically, no. I mean, operability is what this is, and that's what we don't have any assurance that
So
test was
are your
made.
two I thought you had two arguments, but maybe you really have one, that they didn't allege that it was a gravity knife and they didn't allege that it was operable, but those are the same thing, aren't they?
I mean, there's so much overlap. I mean, this Court has previously recognized that when operability is an element, the accusatory instrument has to include factual allegations. I mean, we're relying on that case. But basically, a gravity knife has to operate and lock in a certain way. And the reason that the legislature has specifically said that a complaint is subject to the reasonable cause requirement through evidentiary allegations, meaning non-conclusory, is the Court should have some assurance that a crime was committed here. And in this case, it's troubling that, unlike most complaints...
Just saying gravity knife is conclusory.
Yeah, there's not a sound enough basis to infer he did the test.
Could I suggest this, as Judge Graffio indicated, there's a definition in the statute. And wouldn't it then have been incumbent upon the defendant, as his lawyers seem to say but still letting him plead guilty, this does not fit the definition of a gravity knife, at which point the Court either should or shouldn't take the plea. But no one, I mean, the defendant and his lawyer didn't seem to have any problem with the fact that they were going to...
I think I know what you're saying. The circumstances of this case were he was offered a guilty plea to get out of jail, a time-served plea. And the practical reality is you either take that or you pursue your challenge. And he took it. And the reason the legislature has insisted on evidentiary, meaning non-conclusory allegations, is the Court should have some independent confirmation that the crime was committed.
But that was half my point. But I mean, why wouldn't the defense lawyer at that point say, Judge, we move to dismiss this. This is not a gravity knife.
The defense lawyer could have pursued the matter further, but here it wasn't. And the reason here it wasn't pursued further, but there's a jurisdictional requirement.
But isn't it, well, just following up on that, then isn't it, he's conceding that it's a gravity knife. And now here we are, several months later, with him saying it's not a gravity knife. Well, how do we know?
The analysis is to look at the complaint within its four corners, not the allocution. I mean, and it's a non-waivable defect. I mean, this is, these
It's jurisdictional is what you're saying.
Exactly. It's a non-waivable defect. This Court has said for decades that of a valid accusatory instrument is a non-waivable prerequisite. Now, in cases where...
Can you just help me out there, Don? Because if they define a gravity knife, and let's assume for a minute, different defendant. There is a defendant who has a gravity knife and he's charged with it. If he pleads guilty, he could then come back and say, but wait a minute, you just said I had a gravity knife.
That's the nature of these.
And that's jurisdictionally defective, and I walk.
Because the legislature has said there has to be an evidentiary allegation. If it's merely a conclusory allegation, such as you had a gravity knife, like this case, you don't look to the underlying facts because, I mean, the legislature has confirmed the importance that there should be some independent corroboration. Now, apparently it did so.
Isn't it evidentiary in that the officer himself said that he observed it? He observed the defendant in possession of the gravity knife?
He observed the possession of the item which he called a gravity knife. I mean, the crux of what we're saying here is you have to make a leap, and there's no assurance it will be a reliable leap that he did this simple flip test.
If he pled guilty to possession of a gun, can he come back in a month and say, I pled guilty to a gun, but there's no allegation in there that it was either operable or inoperable, so I shouldn't be charged with either?
Well, a gun presents a different scenario insofar as operability is determined through a ballistics test.
No, but they don't say anything about it.
Right. I think that in the case of a gun...
And let's assume it's inoperable, but he doesn't say it's inoperable. So the evidentiary proof that it's inoperable isn't there, therefore I should be able to walk.
A gun is recognizable as a gun, and most guns work.
There's toy guns.
A gravity knife, they're toy guns, but we can assume a police officer knows a gun is a gun. A gravity knife looks like all kinds of things that all of us possess, some kind of folding knife. They're commonly mistaken. In the case of a gun, I mean, at least we have an assurance that this thing is contraband. If it proves to be inoperable, it can support a charge of attempted criminal possession of a weapon. This Court has said that.
He also went on to say he observed a quantity of marijuana, And then there's a whole paragraph about his experiences, professional, and his observations of marijuana in the past.
Right.
So
We're not
you
challenging
would
that.
require, I know, you would require a similar paragraph for the possession of the gravity knife?
That's what's usually done. I mean, there was this case, William, that the appellate term cited in this case. I don't know of any other case where a police officer failed to do it.
What should it say? What's missing? Describe a gravity knife for purposes of making this thing complete.
What these complaints normally say is, I flipped it open using centrifugal force. It locked open in the open position automatically with a button.
Well, isn't that in the information if you get one? I mean, in terms of stating a cause of action, just saying, this is the section of the law that was violated, and this is a gravity knife because. Because what? Because the thing flips open and closed? That wouldn't be enough for you, because you'd say the box cutter flips open and closed.
No,
a jackknife flips open.
It would be enough for me if there was a sound enough basis to infer that the deponent or someone else had seen this thing flip open just with centrifugal force, not peeling it open with your fingers. It's not a butterfly knife that locks automatically. There's all kinds of knives that get confused with these things.
I thought there's no button on a gravity knife.
No, there has to be a button. Part of the definition is it has to lock open automatically. You know, you do this flick motion, and it locks in the open position.
Where's that definition?
It's Penal Law 265.005.
So it's there.
The definition is there, but we don't know that he tested. We don't know that this knife conformed to that definition.
You're correct. The definition has button, spring, or lever.
Right. I mean, the problem is not that we don't know even how he did it. We don't know that he did it. We don't know that he knew the definition. He could have been one of these.
I guess what I'm missing is that when you charge somebody with this, you charge them with the crime, and the crime is defined there. And if he says, I demand a supporting deposition, then you get all this. But if you want to plead before you get a supporting deposition because you know you're guilty or because you worked out a plea, it seems to me difficult to then come back and say, even though it spells it all out here, in fact, I had a table knife and I didn't know what I was pleading.
Well, the legislature has insisted on some sort of independent corroboration from the officer that the crime was committed. And where you just have him repeating the nature of the crime, the factual portion of the accusatory instrument doesn't tell you anything in evidentiary facts to confirm that. I mean, it doesn't confirm the core of this crime, which is operability. For all we know, this was a box cutter.
So you're saying the information's insufficient on his face?
The complaint
no matter what happened after that?
The complaint is insufficient. You look at the four corners of the complaint, you have a conclusory allegation. In Kalin last year, in the court's opinion, you reaffirmed that a conclusory allegation standing alone doesn't
Well, you know, there is a bit of a difference with drugs because the statute doesn't, the definition in the statute doesn't give physical appearance of drugs, whereas this statute is much more specific in terms of the characteristics of a gravity knife.
It doesn't still.
And I'm not so sure a drywall knife or whatever you have couldn't still meet this definition if used in a crime.
Well, the actual way it's used is not part of the definition, but the way it operates, I mean, these things are considered, used commonly. That was what this federal court decision was so troubled by.
But isn't a knife different from drugs in that a drug, you can't, the statutory definition of a drug usually, you'd have to have a chemical test to know whether it really met the statutory definition. So if you had an information that just tracked the statutory definition of a drug, then you would not know how the officer knew that. But here, an ordinary layman can figure out whether something's a gravity knife or not just by looking at by taking it in his hand and seeing if it does what the definition says it's supposed to do.
But there's no assurance anyone did, ordinary layman or officer.
Well, why shouldn't the officer get the benefit of the doubt? He says it's a gravity knife. Isn't he presumed to know what a gravity knife is and not to say it was a gravity knife unless he checked?
Well, I don't know of such a presumption. I mean, in Kalin you had an allegation. I've been trained about this substance. I have prior experience about it. Here we don't have any of that.
Well, I guess what I'm saying is to recognize marijuana arguably requires training. To recognize a gravity knife doesn't require any training other than reading the statute.
Well, I disagree because no one says he read the statute. I mean, you're presuming that all the police officers know all these technical things and that they don't think, oh, I can visually tell it without testing it. I mean, I'm sure there are, and I know there are some police officers who call something a gravity knife without having tested it. That's the danger that this evidentiary allegations requirement is meant to address. I mean, it's a very serious matter, I don't have to say it, to charge someone with a misdemeanor, and the court should have an assurance that someone knows this thing qualifies under the test.
Okay, counsel.
Thank you, Your Honor.
Counsel?
May it please the Court, good afternoon, Your Honors. Terry Ann Llewellyn for the respondent, the people of the State of New York. The alleged defect in this case is not a jurisdictional defect. This Court has only held in 2 instances what are jurisdictional defects in accusatory instruments. One is where the factual allegations are so vague that the defendant does not have enough notice to prepare a defense, or that there is a chance for double jeopardy. The second is where the elements or the factual allegations do not make out a crime. Neither of those 2 circumstances are present in this case.
Which was the problem in Dumas?
The problem in Dumas, Your Honor, was that the complaint did not make out enough factual allegations to show that the substance sold was marijuana.
Well, and in the so you say that was in the latter of your categories, that the complaint didn't sufficiently allege a crime because it was too conclusory?
Actually, Your Honor, this Court did not reach that conclusion in Dumas. This Court did not have the occasion to rule on whether the accusatory instrument was jurisdictionally defective.
So you say Dumas is not necessarily a jurisdictional case at all?
Absolutely, Your Honor. That decision was never held in Dumas. It was never held after Dumas.
And how do you apply Kalin to this situation, to this case?
Kalin applies here only to the extent that it actually affirms the Court's holding that there are 2 circumstances where a complaint or a accusatory instrument is jurisdictionally defective. And those 2 I just previously discussed, the 2 circumstances. And that's not present in this case. Kalin also affirms Dumas's requirement for the extra language with regard to identifying controlled substances and marijuana.
Do you think there's a significant difference between a knife and drugs?
Absolutely, Your Honor. With drugs, it is not always readily identifiable. You have white powders that can be flour, it can be cocaine, it can be sugar.
I guess your opponent's saying that's the same case here, that there are a lot of things that look like a gravity knife that may not be.
Well, in that case, Your Honor, the gravity knife is more like a gun. A gravity knife does not look like a pocket knife. And furthermore, there are instances where police officers are able to identify a gravity knife.
What's the difference in the look of a gravity knife and an ordinary pocket knife?
There are circumstances where police officers identify that the gravity knives have a distinguishable clip on them, or the gravity knife is shaped in such a way that they recognize it to be a gravity knife.
Shouldn't the police officers say so? You don't deny that it's conclusory what was said here.
Your Honor.
I mean, would you characterize it as conclusory?
No, Your Honor.
Why? Because there's a definition of the statute?
Absolutely, Your Honor. The gravity knife, the word gravity knife is already defined in the statute.
Is a switchblade a gravity knife?
No, it's not, Your Honor. A gravity knife is, as the statute...
You don't think, as Judge Reed said, that there are, things that look like gravity knives but aren't gravity knives? Isn't that obvious?
In that case, Your Honor, that's an issue for trial. That's not an issue for the accusatory instrument. The issue... But
the accusatory instrument allows you to go forward. Shouldn't the police officer say, like in a drug case, I know a gravity knife when I see it, and this is a gravity knife, or this is so elementary that he doesn't have to say it. Is that what you're saying?
It is exactly what we're saying, Your Honor.
To the police officer. It's not to me or to you, I assume.
Well, Your Honor, we are actually charged with knowledge of what a gravity knife is, as it is defined in the penal law. So if we are calling an item a gravity knife, we're saying that it satisfies that penal law definition. Now, going down the slippery slope of saying...
But isn't the definition an operational definition as opposed to a visual definition? In other words, a gravity knife is defined by its method of operation, not by how it looks. It could look any number of ways. Isn't that so?
That is correct, Your Honor. And the issue with that is that there are officers who can tell that it operates in a certain way.
But shouldn't they say then that they have the knowledge to know that it operates in a certain way? similar to the drugs, even admitting that there are differences, and as you say, there can be different drugs, and you got to be able to recognize it. Couldn't you argue that it is a common sense analogy to say that it's the same thing here, that there are things that look like gravity knives, but they're really not? So you want to say, look, I know it when I see it. I've been trained, as opposed to I wouldn't know the difference if someone showed them to me of what looked like a gravity knife and what is a gravity knife. Why would the same just common sense logic, if the statute requires some evidentiary support or allegation, why wouldn't that make sense, that before you could go forward, there'd be enough to allow you to go forward?
Your Honor, what's stated in this complaint is enough to go forward. What the defendant is asking for in terms of saying that the opponent in an accusatory instrument needs to say that they are trained to identify this item.
Well, say something that
What
gives...
about I flipped it open and it stayed locked in place?
Well, Your Honor, just making that statement doesn't take it any further beyond the reasonable cause requirement.
Well, at least you would know that it's not something that looks like a gravity knife but doesn't operate like one, or isn't one because it doesn't operate like one.
Well, in that same instance, Your Honor, you have cases where there are guns that don't operate like guns, but they look like guns. We don't require police officers to say that I know this is a gun because it has a handle and it has a clip lock, and I know what guns look like because I've dealt with guns before.
Can you tell me if, in your experience, is this typical of what's put forth? Your opponent seemed to suggest that a lot of times officers did say more, or deponents did say more. Do you have any thoughts or any comments on that?
There are circumstances where other accusatory instruments do state more.
With respect to gravity knives?
That is correct, Your Honor.
One of the things that struck me was that it appeared that the defense counsel said, as far as I know, Judge, it's a box cutter. If that fits the definition of gravity knife, then I think we're all right. Should the court have done something more here? I mean, if in fact it was a box cutter, you would agree that it's not a gravity knife, correct?
That's correct, Your Honor. The court did do something more. The court asked a further question. The court said, well, is it a gravity knife or isn't it a gravity knife? And the defendant said, yes. So the question of whether it is a gravity knife or not has already been resolved.
And how was it resolved?
By the defendant's admission that he possessed a gravity knife.
That, of course, that doesn't make the complaint sufficient.
No, Your Honor.
Does that mean, though, that if he walks out, when he goes home now and goes back to his job doing drywall and says, I can't use this box cutter without getting arrested, that he's properly defining what the court told him?
Well, Your Honor, the fact that the defendant called it a box cutter does not mean that it is a box cutter. What he did was
But the fact that he called it a gravity knife doesn't mean it's a gravity knife either.
We don't have a description.
That's correct. We don't have a description, but we have an admission. The defendant said, I call it a box cutter. I use it to cut sheetrock.
If he said, I know I'm charged with the possession of a gun, and here's my gun, and if I pull the trigger, I can light cigarettes with it. So if you call that a gun, I guess I'm guilty of possession of a weapon. Would the court say, is it a gun, yes or no? And he says, yes. He says, okay, you're guilty of possession of a gun, even though he's guilty of possession of a cigarette lighter.
In Buffalo.
No, Your Honor. But that's not what we have here. We have the defendant says, I call it a sheetrocking knife, or I call it a box cutter because I use it to do sheetrocking. Just because he uses it for that purpose doesn't take it out of the per se weapon category.
If we assume all of that, is there anything in this record, if we look for it, that would prove to us that this weapon, that this knife, was gravity operated, that had a spring, that had the button that Judge Graffio was talking about, that we would know fits the definition as defined in the statute?
The proof is in the defendant's admission.
That's all? The yes is it?
That is it, Your Honor.
You're happy with that?
That is what is that is what is presented in this case.
Okay.
There was no other question. The court said, did you possess a gravity knife? The defendant said yes. He didn't say, well, I don't think so. He ultimately said, yes, I did.
It is my information that it was a box cutter. If that qualifies as a gravity knife such that he can open it with one hand, then that would fit the definition.
That's the attorney speaking, Your Honor.
Then Dryden said, it's a sheetrocking knife.
That's what he claimed he used it for.
Well, the quote is, well, he called it a sheetrocking knife. I didn't have the full quote. Yeah.
Because that's pretty much what he was saying he used it for. But that doesn't mean that it's not a gravity knife. And the very next question after that, the court says, well, it is a gravity knife or it isn't a gravity knife. And the defendant says yes.
So is that admission what you're going on? Are you saying that the instrument is deficient, but because he admitted it, then it's okay?
Absolutely not, Your Honor. The people are not conceding any deficiency in this complaint. The complaint satisfied the reasonable cause requirement. It satisfied the factual evidentiary requirement in stating that the officers saw the defendant in possession of a gravity knife and recovered the gravity knife from the defendant.
But you're saying if there was a deficiency, this cured it, even though you don't admit that there was a deficiency?
No, Your Honor.
No. Go, what do you say?
If there is a deficiency, first of all, it's not a jurisdictional deficiency because the defendant is only alleging that these statements are conclusory. So he's challenging the sufficiency of the factual allegations.
Would you call it a pleading defect?
No, Your Honor. This court has held that a challenge to the factual sufficiency in a pleading or an accusatory instrument is not a jurisdictional defect. And the defendant
Is there something between a pleading defect and a jurisdictional defect? Because we said in Dumas, sounds like you know, we said that it wasn't just a pleading defect. But you're saying that Dumas wasn't jurisdictional. So was it something in between?
It's not in between, Your Honor. It's a different
A
category.
third kind.
Yes, Your Honor.
That third kind have a name?
It's not jurisdictional. And the defendant here waived any challenge to that defect.
I mean, I guess I can't.
He wanted to get out. He was at arraignments. He was going to get time served. He wanted to leave.
He had the right to a pretrial hearing. He had the right to a trial. He gave up that right. He gave up the right to have the people prove beyond a reasonable doubt that he possessed a gravity knife, and he admitted that he possessed it.
But they were offering him time served, right?
That's the
He
judge
was getting ready to
offered
walk
time.
out the door. Isn't it likely that he would have admitted to just about anything at that point?
Likely, Your Honor. The standard is whether he did it or he did not. So in this case, he chose.
But the reality with which he was faced was whether he was going home or not.
Well, if he did not, in fact, possess a gravity knife, he could have gone home. He could have challenged the fact that the item recovered was a gravity knife. And if
In reality, I mean, I'm not sure this case turns on it, but in fact, if he had said, no, I don't admit it's a gravity knife, I say it was a paper knife. Isn't the judge going to say, okay, we got a dispute here, come back in 2 weeks?
Exactly, Your Honor.
And he may not want to spend those 2 weeks at the place where he was then living.
But he had that right. That's his constitutional right to have a trial or to have a pretrial hearing. And he gave up that right. No one forced him to do it. He said he wasn't forced into the plea. He gave up the right. He forfeited his claim now that the people didn't prove that the knife was
Let me take you back for a minute to the marijuana cases. I mean, there's Dumas and there's Kalin. Reading them, don't you get the impression that even for jurisdictional purposes, you have to say more than he possessed marijuana?
For marijuana and controlled substances, yes.
What's the difference between marijuana and a gravity knife?
The difference is the very nature of the object. Marijuana is not always readily identifiable, whereas a gravity knife, by definition, is identifiable by its distinguishing characteristics as a knife. It's
not necessarily identifiable by appearance. You say sometimes they're identifiable by appearance, but typically you have to actually try them out to identify them, don't you?
There is more than one way to know whether it's a gravity knife. You can either see someone flick it open, you can flick it open yourself, or based on your experience and knowing what their distinguishing characteristics are, you see a gravity knife.
Don't you have to list one of those tests in order to make the accusatory instrument valid?
Not necessarily, Your Honor.
Know that it's operational.
No, Your Honor, because the fact that the officer is saying that it's a gravity knife, he's saying that it fits the operational definition of a gravity knife.
Okay, counsel, thank you.
Thank you, Your Honors.
Yeah. Rebuttal, counsel?
Your Honors, this case really does show the importance of these misdemeanor accusatory instruments and what the legislature had in mind in saying, you know, we need some evidentiary allegations, some confirmation a crime occurred. I mean, you can easily picture a rookie police officer, someone on desk duty for a long time, even someone who's just listening to what their colleagues are calling a gravity knife, but not really knowing those elements that are in the statute, and might think a switchblade is a gravity knife, to borrow Judge Piggott's question. But this defendant was convicted under the gravity knife provision. And we have to have
He was charged
some
with possession of a weapon, and it sounded at the end like the judge, you know, didn't want to debate it and said, you know, was it a weapon? It was a weapon, yes or no? And he said yes.
It wasn't a question, Judge. The plea judge said, then it was a gravity knife. I believe that's what he said.
He says a gravity knife is a weapon, so it is a yes or no to that question.
Okay.
And the defendant says yes. I see your point.
And then he says, so it's a weapon. So, you know, I just underscore the importance of having these requirements for independent corroboration.
This case would be, from your point, this case would really be exactly the same. The case before it would be exactly the same. If you had the world's most perfect allocution, and he said it was a gravity knife, and he held it up, and everybody in the courtroom saw it was a gravity knife, you still say the complaint's deficient.
Yeah, true. I mean, we look at the four corners of the complaint, and there's no supporting.
But is it jurisdictional? Your adversary says that it's not, because there's only certain jurisdictional defects, and even Dumas is something else, but not jurisdiction.
Right. I mean, Dumas was a people's appeal. But what this Court has said repeatedly for many years is that a valid accusatory instrument is a non-waivable defect. 100.40 is jurisdictional for informations. You know, we submit that it has to be.
Well, there are flaws there is such a thing as non-jurisdictional flaws in accusatory. How do you know which ones are jurisdictional and which ones aren't?
Well, I mean, Casey is the case that discussed that the hearsay problem of the prima facie case needs to be objected to. But where, you know, when you have a waiver of information like in this case, that takes away.
In Kalin, we said the ultimate holding in Kalin is that the defendant's claim was forfeited. We did admittedly look at the instrument to decide it was forfeited, but presumably there could have been some defects that could have been raised but were forfeited because he pleaded guilty. What sort of defects are those?
You know, I don't think a reasonable cause could be that defect, and I don't think evidentiary allegations could be that defect. I mean, I don't know what those defects might be if they exist at all. But here it's the core of the core of this crime is, did this knife operate in that way? It's not established by an evidentiary allegation. It's just a conclusory allegation. In Alejandro itself, there was a conclusory allegation on the lawful arrest element, which is what this Court found.
Well, the charge here is possession of a weapon, and the evidentiary thing is that it's a gravity knife, which is I think that's
it's possession of a gravity knife, though.
Pardon me?
I'm sorry to interrupt, but it is possession of a gravity knife. That's the specific weapon, not just any weapon.
But no, they put out that big definition of nunchucks and switchblades and everything else, and the evidentiary part that he gave you so he could define it for you was none of those. It was a gravity knife, which is self-defined in the penal law, I guess.
Well, but that narrows their theory to only that possible weapon.
Right.
And my final word would be.
Final word, go ahead.
Would be that this Court has repeatedly treated conclusory allegations as a total absence of factual allegations. It should do that as well here. Reasonable cause wasn't established.
Okay. Thank you both.